We're ready to go. Sure.
This is Chair Douglas. We're going to call our meeting to order this morning. If we can have our roll call of the board members.
Great, thank you. Member Jerry Merritt?
Present.
Member Dennis Nylander?
Present.
Member Rihanna Durrett?
Present.
Member Brian Young?
Present.
And Chairman Michael Douglas.
Present.
Great. Deputy Bollock, can you please confirm that we have complied with the open meeting law requirements?
We have, sir.
Great, thank you. With the chair's approval, I will get started by introducing agenda item 1. Agenda item 1 is public comment. We have not received any public comment thus far, so we can move on then to agenda item number 2. Chair, these are the meeting minutes.
We have the meeting minutes have been posted. They are part of the package the board members have received. If we have members who've reviewed them, if they please make a motion for acceptance. Second. Or any additions or corrections.
I have no additions or corrections, and I'm prepared to make a motion, Mr. Chairman.
We have a motion for approval from Member Nylander. Do we have a second?
This is Jerry Merritt, second.
We have a motion. We have a second. Any discussion as to corrections or any other items? Hearing none at this time. All in favor, please say aye of approval of the minutes as so posted.
Aye.
Aye. Any opposition? Hearing none, and we have no corrections, so we'll move the agenda.
Great, thank you. So agenda item 3, this is the briefing to the board regarding the January 19th, 2021 workshop. I'll now turn it over to Member Young to give an additional update on the recommendations.
Director Tyler. Good morning, everyone. Since our last meeting, brief update, I'll try to be brief, is met with Zeal, had some correspondence regarding one of their studies. We had some additional public comment, and things have been fairly quiet since that time. I think probably time to move forward on this issue. In regards to NCCR 12068, it is probably overly broad and is probably going to need to be repealed or amended. I think the bigger issue is the consumers have clearly want to be informed regarding the product, which I think becomes a labeling issue. And I'm hoping that maybe that we can bring this or defer this until I believe there's going to be a workshop regarding labeling. I know there's going to be there's definitely some legislation that regarding the CCB's response and need for labeling in regards to a pamphlet. I also wanted to make a comment in regards to the technologies, that they definitely appear safe to the consumer, which I think is obviously the most important thing. And I don't know if I could direct this back to you, Director Tyler, in terms of how we would proceed with a workshop or something in regards to labeling to get the entire board involved so we can make a final decision.
Sure, thank you, Member Young. And so the legislation that Member Young references is SB 168. And at the end of the day, what this would do is provide flexibility for the board to promulgate regulations around packaging and labeling, essentially envisioning a decision regarding what needs to be included on the actual package, what could be included in, let's say, a pamphlet that is included with the purchase. If that bill passes, which it's likely to pass, we will then proceed with a workshop around those decisions. I think what Member Young is saying, we could then include the conversation around 12065 in that discussion, therefore workshopping where it is and what it says, but at the end of the day, still being information informing the consumer that a product has been remediated. Therefore, so we would continue this matter then until a workshop, which would take place, shortly after June and the passage of SB 168.
And I think that would be absolutely appropriate. I do think that we're going to need some type of labeling on all product that undergoes post-harvest remediation, but something more that would more broadly for all of the different industries, so that the consumer would just be better informed and know what happens with their product.
This is Chair Douglas for the record. And Dr. Young, just thank you for doing the heavy lifting on this. You're probably the person most capable of all of us to read through what's been provided to you in terms of the science. Tyler, isn't there some additional legislation about working with another one of our health departments about information or generally marijuana? It's also pending, or is that within the same bill that we have to work with one of the other state agencies?
I'm not sure what you're referencing. On the health side of things, there's some DPS bills in there that we have to work with the Department of Public Safety. And I guess you could consider SB 168 in advertising. We would work with the health agencies certainly on that, or as a component of that item, if that's what you're referencing.
There was something that was out there that gave some responsibility as to product content to one of our agencies. At least it was pending.
Right.
So I think the measure of continuing this until after the legislature has spoken makes good sense at this time.
Okay.
So with that, we will move the agenda. And for the public at large, we're looking, once the legislature has cleared their decks and given us some guidance as to what they are expecting of us and our latitude, we will put this back on the table, as Dr. Young says, for a workshop to have that discussion.
Great. And Chair, just, consumption lounges, the consumption lounge bill does envision a relationship with our health departments and county health departments. That may be what you're referencing as well. Okay, moving on to agenda item number 4. This is the request for transfers of interest. I'll note for the chair and the board that item number C has been continued to the May board meeting. So that leaves A, B, and D today. So
And that was, for the record, compassionate.
that is correct, Chair. Compassionate Team of Las Vegas. So with that, I will turn it over to Chief Staley to present this item.
Good morning, Chair Douglas, Member Merritt, Member Nylander, Member Durrett, and Member Young. For the record, I am David Staley, Chief Investigator for the CCB. I'm here to present agenda item number 4, which now consists of 3 transfer of interest or TOI applications. Item A are the TOI applications for Curaleaf Holdings, Inc., or Curaleaf. TOIs number 19071, 19090, and 19091 request approval for Curaleaf to purchase ownership in NatureX2 LLC, or NatureX2, from Robert Frey, Brian Kessler, and Andre Bloch. TOI number 21015 was assigned in error to a request to update officers and directors, and is included in this report to administratively remove it from CCB records. In addition, Curaleaf has requested waivers pursuant to NCCR 5.112 and 5.125 of the requirements of NCCR 5.110 regarding a review of all owners, and NatureX2 has requested a waiver pursuant to NCCR 5.125 for Kyle Wyloge. Curaleaf and NatureX2 have adequately addressed the items required in NCCR 5.112 and 5.125 to allow the board to approve such waivers. Staff suggests that if approved, the board limit Curaleaf and NatureX2's 5.112 and 5.125 waivers to expire on such agenda date as their next TOI application is heard. Staff identified areas of concern with TOI number 19090 because it appears that Curaleaf purchased a portion of Bloch shares before the requested board approval was received. Staff identified additional areas of concern because Curaleaf completed the issuance of securities to various of its officers and directors between 2019 and 2020, and a shareholder divested his shares without filing TOI applications or prior board approvals. CCB staff have provided potential options for the board's consideration to proceed with TOIs number 19071, 19090, and 19091, and have explained those options to Curaleaf's counsel and included Curaleaf's response in the investigative report. I am available for any questions, and my understanding is that Amanda Connor is present today via Zoom to address any questions you may have as well. With that, Chair Douglas, I'll turn this item back to you.
All right. I'll just say before I ask Councilor Connor to speak on behalf of the licensee, I do have some concerns. They may go away, but have some information issues as to the stock transference or the selling of stock by one of its members. Their response was they're not responsible for that, but I know they have some information as to new members coming in and so on. But since I don't know how the stock was transferred, whether all the percentage of that one particular person was transferred in bulk, or whether they were smaller transactions that would have kind of gone under the radar. At this point, I just don't know. So I'd like to hear from Ms. Connor.
Great, Amber, if you could unmute Ms. Connor when you're unmuted, please go ahead.
Good morning, Chairman, members of the board. First, I'd like to, on behalf of Curaleaf and my clients, thank staff. They spent a lot of time going through this transfer and I believe put together a pretty comprehensive report. Chairman, to address your question, I would ask, I have General Counsel of Curaleaf with me today. He's attending separately in a separate location, Peter Clateman, as well as their Director of Compliance, Kayan Ticey. I would ask that they be permitted to join because he may have more direct information on that specific divestment of shares that you're asking about.
That'd be fine.
But Amber, if you could please unmute Mr. Clayton. And if when you're unmuted, please go ahead.
Hello, are you able to see and hear me?
We hear you. Thank you. Good morning.
I think I understand which transfer you're talking about. I think we made the responses to the investigator about the nature of the company. We're a public company, publicly traded. We do not have the ability to stop people from transferring shares. They do it on their own without our involvement. We are able to see if the owner, the direct owner of the shares, does not have shares in the trading system. We cannot trace individual trades of shares if they're publicly traded, but if the shareholder has not deposited their shares into the publicly traded depository system in Canada, we would see them as the direct shareholder on a register. So we have pulled that document with respect to the transfer you're talking about, and we can provide that would show a transfer in October of 2019, I think relates to the one you're talking about. It would just show the direct legal entity transfer. It would not show who owns that entity, but we have found that transfer with the records of the depository, which is something called Odyssey Trust Company in Canada, which most of I think you are probably at this point familiar with some of the other publicly traded cannabis companies. They use the same company, and that, if the shares are publicly traded in the depository system, you would not see it. But this particular shareholder, when they transferred the shares, they were in the depository system, in the transfer agent in Odyssey. So we did see the transfer, and we can provide you with that record.
This is Member Nylander. I have a quick question for.
And excuse me, I'm sorry to interrupt, but I cannot hear Member Nylander. I know it's him, but I can't hear him speaking. Sorry. It sounds like you're muffled.
Is this any better?
Yes, Dennis. Thank you.
Yeah, it is. Thank you. I'm sorry to interrupt.
No worries. No worries. Just for the general counsel, Mr. Clayton, is there a requirement under Canadian securities law that you report transactions above 5% if you're aware of them? So in the US, it's called a 13D or a G, but it's a requirement to report anything over 5% to the exchange. And then that is often coupled with various regulators, depending on what industry you're in, that also be reported. So I just don't know for Canada how that works.
It's 10%, and the burden is actually on the shareholder.
Okay. Okay, but it's not at 5, it's at 10.
Yeah.
Okay.
Well, Chairman, may I follow up to that?
Please.
Mr. Kleitman, you could require of shareholders purchasing your stocks within your articles of incorporation and or some mixture of your offering that they report over 5%, right? So at this point, maybe you don't have control, but before you do any kind of offering in the future, you could make those, you could place those terms, correct? And not come back and say we have no control.
We could. I mean, we could, but we did not do that. We would have to adjust. We do poll for the 10% limit. We do let people know that it's out there and that they're required to do it. But no, we have not put that in our articles.
Thank you. That because I really want to get across to the licensees listening. It's understandable if that didn't occur in 2019, given the standards at that time. But going forward, that has to happen, and publicly traded companies can't come back and say we don't have control, because you can put that in your articles and in your offerings, and that in the future that they also understand that this, in the privileged area, it's not going to be treated like every other publicly traded company. It's going to be different in cannabis. And that may mean you're doing things differently state by state, but that's the nature of having a federal conflict, and having state legalization is it will differ and it will be difficult. But going forward, those controls have to be set in place.
Even if we have the requirement in the articles, we would not be able to police it, because once the shares are in the trading system, the way that people hold their shares does not show to the company, the beneficial owner, or even the direct owner. So we would, as the company, we would only see the Canadian depository system as the shareholder. The way shares of publicly traded companies are held is through a series of custodians. So we can ask, we can poll, we can ask people to respond, but we don't have a way to police that.
Well, it would allow sorry, Chairman, it would, I think, it would allow the regulators to do it, because they could impose certain requirements, but it also, couldn't you also require disclosure of identity as well?
We would have no way to police it. We would have no way if they weren't doing it. We'd have no way of knowing. So the burden is on the shareholder. The burden is on the shareholder, but we can't force them to do it. We can, if we found out, we could put a provision in that would punish them, but we wouldn't necessarily know when it happened.
You could require, again, you'd have to do it up front. You can't do it now retroactively, but you could require, if you've found out, divestment of their shares, right? And also regulators would have some ability to address it as well.
Right. Yes, if we found out, we could build in certain actions we could take.
And if I could jump in, it is my understanding, and Mr. Kleitman can confirm, but my understanding is there is a provision in their articles that if they become aware that someone, one of their shareholders cannot comply with regulatory requirements, they do have the ability to take action, correct?
Correct. we have the ability to take action. It's it's on a practical level. It's pretty extreme. When you get rid of a shareholder, you have to come up with the money. So I imagine that's not possible for a lot of companies. And then if you're talking about a large shareholder of a public company, that's quite burdensome. But yes, we have a provision that in theory allows us to buy out a shareholder who is not approved, is found to be inappropriate as an owner of one of our licensed subsidiaries.
Thank you, Chairman, for the time. Like I said, I just want the board and licensees to be on the same page about what is possible and what isn't going forward. Thank you,
Well,
Chairman.
I appreciate the comments. My concern is that we have compliance with the laws of the state of Nevada. I understand we have a publicly traded Canadian company in play and certain things in their articles. However, we have responsibility for understanding who has ownership in these companies, and in some cases, the need for them to be investigated. Others fall under the threshold, don't have to be. What I'm concerned about, we have a chunk of stock that was transferred. We have little information as to whether it was sold in bulk or sold in pieces. Sold back to the company, we don't know. All we know is we had a investor divest itself. And so I think I would like to see more information about that divestment and information when it came on their books as to how that stock was broken down, whether it was purchased by the company or not. I don't know. I don't know if we have a technical violation or whether, in fact, as Member Durrett said, it's something that under the existing law at the time, it's kind of no harm, no foul, because we do understand the difficulty. But this is something that we're trying to understand and trying to grapple with and be fair to the publicly traded companies, as well as our obligation to enforce the laws of the state of Nevada. So at this point, I'd like to see, based on what I'm getting, a little more specific information as to what happened in this case, because it's never been said specifically that it wasn't purchased by the company. It hasn't been stated specifically that the individual or individuals who purchased the percentage that was divested were over or under a particular amount. I don't know. And because I don't know, I'm not comfortable at this point voting to approve that particular TOI transaction. The others seem to be fine, but...
Chair Douglas, if I may.
Yes.
This is Chief Staley. The company provided information indicating that Curaleaf did not repurchase those shares from the investor. What we were unable to get any information on at this time is specifically the schedule of when the investor sold their shares in October of 2019 and to whom they may have sold it to. But the company has provided representation that Curaleaf itself did not purchase those shares back from the investor, and perhaps Peter can clarify that on the record.
If I can jump in real quickly, Chief Staley, you did state that correctly. We were also able to confirm the date. It was October 16th, 2019. That was provided to investigator Maurer. Peter may be able to add additional information, but the win and it was the third-party transaction. Curaleaf did not redeem the shares, was previously confirmed.
Thank you for that.
That's correct. And I mean, we would have, there would have been on even doing that, which wouldn't have been possible. And in addition, we would have been disclosed, which it wasn't. And I can also say that it's because there's a reporting obligation on insiders. It does not appear that the shares were bought by any insiders. I said because they would have had to report that. So it does appear to be third-party transfers. And as I said, we have pulled in the last 24 or 48 hours, we did pull the record. It does appear that the companies that were transferring the shares didn't hold them in the depository system. So as I said, we were able to see the names of the companies that own the shares and the two companies to whom they transferred to. We do have that information.
Well, at this point, I am still concerned because I have just received this information, this date. The other that you've just spoken to, I'd like to have an opportunity to digest that. That's my unreadiness. I don't know if my colleagues have any concerns or if they're ready to go forward. So any other board member wish to weigh in on this at this point, or have your questions at this point been answered or unanswered?
Chairman, should we address the other transfers at this time?
I think if that's appropriate, I have no problems with the other transfers. Just that one. So I think I think we're able to do that and separate that one out and move the other ones along. So if we can have a motion as to that, if that's what the board would like to consider at this time.
Mr. Chairman, this is Member Nylander. I'm in agreement that we should probably hold that one in abeyance until we because we're getting additional information today. I'd like a chance to also mull it over. I understand the company's position that, when there's a transfer, the burden is on the shareholder to report it, but I think within the Nevada regulatory system, we have certain requirements, and our threshold and the SEC and the US threshold is 5 instead of 10. So we've got to figure out a way to make that work for everybody. But for the record, Tyler, because we have these file numbers, I just want to make sure the record's right. So on these TOIs, we would hold out one of these, and I assume, my motion would be to approve the rest because they're not relevant to this. So which on the agenda, perhaps Mr. Staley, maybe it's more appropriate for you, but the way the agenda is posted, we have actually 4 file numbers and 2 different companies. So which would be the best way to do it?
Maybe Chief Staley, given that some of them are somewhat connected, what is your desire? What would be the easiest way to do this? Would it be easy to pull them out, or is there another action that may be cleaner?
Chair Douglas, this is Chief Staley for the record. The sale of shares by the third-party independent shareholder is not specifically tied to any individual TOI. The TOIs themselves relate specifically to different transactions that were requested by the company. The areas of concern that we identified on some of the additional transfers relate to Curaleaf Holdings applications in general. I think that in this case, it may be an all or nothing, but it's just specifically the way I read the specific TOI application forms. The board can decide how to handle it however they see best fit. But these areas of concern transactions don't tie to a specific TOI number.
And if I could step in on behalf of my clients, really, we agree with Chief Investigator Staley that the areas of concern are areas of concern related to Curaleaf, the company, and these transactions have been pending for quite some time. And the areas of concern are not specifically related to one transfer. We provided the information requested by the investigator. We understand that very recently to whom the shares were transferred question was asked. And as Mr. Kleitman alluded to, he was able to pull the Odyssey report in the last couple days. And we're happy to provide that information, but we did provide the date to Ms. Maurer back when she was investigating, and the confirmation that it was third-party transaction, not redeemed by Curaleaf. We understand that there were some gray areas in 2019. My clients understand that the CCB has the obligation to overtake this program and implement the laws, and that, you know, while there was not clear guidance for publicly traded companies when under the governance of the Department of Tax, so they did their best to comply. They understand there may be some concerns. We would kindly request that the board approve the transfer, and if there are areas of concern by the board, that be addressed through a stipulation and perhaps a settlement, instead of continuing to hold these transfers that have been pending for quite some time, years.
This is Chair Douglas. I appreciate that. However, from my standpoint, as you indicated, our obligation is to implement the law as so stated. We appreciate the assistance that's been provided over the last 24 to 48 hours, along with the initial response to the questions of the investigators. However, you must understand that as a board, if we have an unreadiness, we are not to just push it forward, we are to look at it. And very much because you've been one of the longtime people in terms of coming before the board and the tax department previously, you understand that we are a work in progress and trying to articulate rules and regulations that make sense both for the board and the licensee. And it's not our willingness to or intent to attempt to punish a publicly traded company. We are just trying to make sense of what is going on, and where we have different rules butting up against each other so they make sense for all the parties involved. So we want to, at least from my standpoint, I would like to take another look at this and make sure we as a board have all the information that's possible. That's why we were looking to see if we could possibly carve out part of this and approve, as you've indicated, the other transactions that have been pending for some time. But I heard a kind of an unreadiness from our chief investigator at this time. Unless our chief investigator has a way that we can kind of approve part of them and not others, because he's saying this is a kind of a global situation with all the transfers, then I would make the motion to hold until our next meeting to make sure we've gotten all of our questions answered. And even if they're not answered to our total liking, if we understand it right now because of the flux of rulemaking and publicly traded, we would probably go ahead and approve it without a problem. But as I said, there's some information we just got. As Member Nylander said, and I concur, we just like to kind of take a second look at this. So that's where I'm at this point. So, Mr. Staley, have you any other thoughts since you had an opportunity to have a little more time to think about this?
Chair Douglas, I do not. I was sitting here trying to think if there's a way that we could carve one TOI out of the others. The way I understand it, TOI 19071 did not have any areas of concern on itself, but however 19090 did. I with the nature of the transfer of interest applications, the only way that it may work is if we, let me make sure I have this correct. So 19071 was the transfer of interest application whereby Curaleaf purchased the interests of Mr. Frey and Mr. Kessler, their interest in NatureX. There was not an issue with that one, and the way that we evaluated that transaction was that it occurred appropriately under tax. We could pull 19071 out and apply the general areas of concern to any possible settlement agreement to 19071. The board could deliberate on whether or not to approve 19090 and 19091. However, 19090 does have an area of concern attached directly to that TOI number. But if council is comfortable, and I think I'm just speculating here, if council and the company indicated that they were comfortable moving forward and holding 1907071 until the next agenda, and then any areas of concern addressed in the report under 19090, 19091, and the general ones could be handled relative to 19071, possibly that would work. That's confusing. I don't see any other way to assist the company to move forward and to maintain our oversight over the issues.
Well, I think just speaking for the company, I mean, again, these transfers have been pending well over a year and a half. I do think we've been quite forthcoming. We have agreed to stipulation and settlement. The transfer we're talking about, I think we did confirm it did occur. I think at this point, you're basically looking for information as to whom they were transferred. We've confirmed it's not the company. We're talking about a block of shares that I believe at this point barely exceeds the 5% level. And again, these are indirect shares of an indirect holding company. There's no dividends being paid by the licensee companies. There's no money going in to the licensee companies from whoever this shareholder may have been. So I think there's a pretty big disconnect between this particular packet of shares and the transfers that we're asking to approve. So I do ask if the board can consider approving, subject to our providing the information on the transfer, which is, as I said, the most information we will have is this report, which we can send immediately, which shows the transfer of these packets of shares to other legal entities.
Chair Douglas, I may have something that'll work.
Please.
TOI number 19090 was a two-part acquisition, or the first part of the sale of NatureX shares from Andre Bloch to Curaleaf. It was a two-part transaction. The first part, and Ms. Connor, if you can correct me if I get this incorrect, the first part of 19090 has occurred. No, the first part of 19090 we determined had occurred under taxation and was not an area of concern. The second part of 19090 occurred later, and we have determined that is an area of concern. I believe that the board could take 19071 and 19091 and to determine whether or not to approve those. We could hold 19090 and apply, because that has an area of a concern associated with it, and apply the other areas of concern to Curaleaf as a whole to that same TOI number, because the transactions requested have already been occurred under that TOI number. And we could move forward that way. So I believe the company would be able to move forward on the transaction for Las Vegas Natural Caregivers since it's pending. And that may work for both parties.
Chief Investigator Staley, if I may, just to make sure I'm understanding what you're discussing, and to help my client along, you're suggesting that the 19071, which is the buying of 18% of Natrex to move forward today, and that the 19090, which was the 80% acquisition through VSLV, be held pending additional information. Is that what your proposal was? Just so I can make sure I understand.
I think that would work. And then 19091, which is the Las Vegas Natural Caregivers, would move forward as well.
I think as suggested, and I know the board has to, we defer to the board and they have to deliberate, but we would kindly request that, you know, all move forward, including the areas of concern, and that just part of any stipulation is that we provide the information to staff on that share transfer, you know, to be considered. You know, like we said, the company does not dispute that the shares were divested, and that it was, you know, a transaction that occurred in 2019.
Chair Douglas, this is Chief Investigator Staley again. That I believe that may work. The company, depending on which option the board chooses as part of the options that staff presented, if the board determines that it wants to move forward and have our Deputy Attorney Generals discuss a stipulated settlement that would be heard on the May agenda, which is consistent with some of the actions taken in the past, we can move forward with the company to present the information to you as part of your review of that stipulated agreement on the next month's agenda. I think that would hopefully allow the board to get a comfort level with the information, but still stay on schedule with when the first time that a stipulated agreement could have been heard by the board anyway. I defer to you.
Not speaking for the entire board at this point, only speaking for myself. I would be comfortable only with approving 19071 as to Robert Frey and Brian Kessler, as previously, as we indicated, approved by tax, and holding the other two for additional information. And I hate to say possible settlement because I don't know if there even needs to be a possible settlement, but the other two to come back at our May meeting. That's kind of where I'm at. So I'm interested in hearing what other members of the board, their position, to make sure I'm not off the reservation.
Chairman, Member Drett, for the record, I think that last pitch that Mr. Staley gave, I would feel comfortable with that, the way he's proposing approving it conditioned on the stipulation occurring and being able to review that particular transaction we're talking about. So not everything is approved this particular meeting, but it can be by the next meeting. That being said, whatever the motion is, I'll likely go with the board's motion, but as of right now, I do feel comfortable at that last proposal that Dave made. I think it makes sense to, because we can do all the review and still expedite it.
Member Nylander, you were wishing to speak?
Yes, thank you, Mr. Chairman. The one transaction involving an individual over 5%, where the company has clearly stated on the record they were not aware of it. The company clearly did not repurchase the shares. And as my understanding is that particular individual, we do have an application on file in an unrelated matter, although these things all seem to be related together, but I think we can deal with that as part of the stipulation if we need to, or as on the other application we have pending before us. So I'm okay to move forward today with all of these, conditioned that they be addressed in a stipulated settlement with the company. And as if I heard the testimony correctly, the company has already had some, at least internal, I'm not sure of just how much discussion with our staff, but I would be prepared to go forward with essentially what's outlined in our report as item, as option number 4, that we would approve the package, because the only one I'm concerned about that we can't deal with in a stipulation is this one individual who made just market transactions. The company didn't buy the shares back. We still have the ability and we still have jurisdiction to look at that. So I would be okay going with, the option that's conditional approval, that we reach a stipulated settlement with the company. So anyway, that's kind of where I'm at. And I also wanted to, I don't know if this is for Ms. Connor, but the investigators also looked into other jurisdictions where the company's licensed, and apparently there are some thresholds where you have to have a certain number of local shareholders or something. And this was sort of all new to me also. And I was hoping the company could address that either now or else as part of the stipulated agreement. And my concern is just to make sure they're addressing, that they've apparently gone, certain shareholders are over a threshold in other states in the US is what I'm talking about. So as part of the investigative report, the investigators, contacted other states where the company does business to make sure they're in compliance. And there appears to be at least some states where there's some non-compliance with these ownership levels. And so while that's not necessarily our jurisdiction, I want to make sure the company's addressing that issue. So that's sort of where I'm at, if that makes sense, Mr. Chairman.
Any other board member any other board member wish to weigh in at this time?
Mr. Chairman, may I speak for a moment? This is Chief Staley.
Let me just make sure that I don't have any other board member who wishes to weigh in.
Yes, sir.
All right, please go forward.
Mr. Chairman, this is Chief Staley for the record. The shareholder that divested their shares does have a pending transfer of interest application with the CCB. So Member Nylander is correct. We can follow up relative to the actions of that individual shareholder in connection with the specific transfer of interest application they have on file.
Thank you. Do we have a comment from the licensee we wish to make at this point?
one other issue with this is in terms of the divestment, we have confirmed it was to more than one party. So the 5% rule, there was no new 5% shareholder. So they divested, and my counsel hasn't told me whether this is the case, but if the divestment was, I'm not sure where the violation lies if the divestment didn't result in a new 5% owner. So just another factor, to ask you, the board, to consider. The other thing to address sounded like there were some concerns about other states. It's sort of not sure what's being referred to. It's not on the ownership level. You're talking, I assume, about the number of licenses that you're allowed to have in certain states. That is likely referring to Maryland, where we acquired a company called Grassroots. And as a result, that company had a relationship with a licensee. This practice isn't probably as common in Nevada as it is in other states, but they didn't own the licensee, but they managed it. Before we acquired them, Grassroots, we asked them to sever relationships with that licensee, and we were assured that they did. But after we acquired them, because we also have a license in Maryland, after we acquired that company, Grassroots, the board investigated and determined that the relationship between the company we acquired had not been completely severed. But in the meantime, we had agreed to sell the business that we had in Maryland. So we had explained all of this in advance to the commission in Maryland. We had sent them all the agreements, and that's recently been approved. So we were never in excess of the license limit, but we had an agreement with a company that had been severed, and they were not convinced that the timing was such that we did not have, quote, an interest in two licensees. But we had no intention of running them economically, business-wise, there was no point for us to try to run these two licenses, but the timing of our acquiring Grassroots and our divesting of the license, that seemed not to have succeeded in avoiding, in the commission's view, a temporary overlap. I think I'd have to understand if there's something else that was being referred to, but that's my guess at what at the issue that might have been referred to by the investigator.
Yeah, so just so the record is clear, we, to be fair to the company, this is not raised as an area of concern under the existing report we have, but I just want to make sure the company is aware that at least the regulators here are watching what's going on in these other states to make sure you're in compliance there as well. And the other issue, there were a few other states that were raised in the report. And again, I just want to make sure the company is aware that that is, something we are watching, is to be sure that something that you do in another state doesn't tend to reflect negatively here. And so the staff did not raise it as an area of concern, but it was just an area of interest. And I understand that, as I learn more about the industry, that these management contracts are, a fairly common thing, not just in Nevada, but in other places. And that kind of butts up against some of these caps on numbers of licenses, et cetera. And I just want to make sure the company is staying on top of that. That was my whole point there. It was not to be something that would be part of this stipulated settlement if that's the way we go on this.
Okay. No, I appreciate it. And just For the commission that in no instance are we looking to exceed caps. Just as there is a problem for public companies in terms of their own ability to police their shareholders and some of these transfer rules, the commission should be aware there is a difficulty from a company that operates in multiple states when they do an acquisition to time perfectly the divestment. We recognized, and it's even in our public statements, when we signed the acquisition of Grassroots, it was even stated we intended to divest of assets in order to comply with the local rules. Question of timing. How can we engineer an acquisition when in multiple states we have similar limits, slightly different in each state? So I can assure the commission there was an intent to comply, but you can imagine the timing issues as we've had timing here in Nevada. We've been working on this. There was a mismatch in timing, and in Maryland is the one example I talk about, but there's no intention to exceed these limits. It's a question of navigating our acquisitions and getting the divestments done that we need to do in the right timing. And we can assure you that that was the full intent, and we have completed the divestments. If you can follow the whole Maryland situation and all the public disclosures, it's all public, and we were approved for the transfers to complete the divestments, I believe last Thursday.
Yeah, and I appreciate your response, and our record does reflect that. So it's the commission there was aware, and we were working with them to make sure that was done in an appropriate manner. And so, but it just looks like from, and I understand the difficulty with it, with all these states having different requirements. And you might have a nanosecond transfer that, the timing is difficult to pin down, but I just want to make sure the company's on top of that, because that is part of our investigative process, is to make sure that you're not doing something in another U.S. jurisdiction that would cause problems for Nevada. So that's the
and
point.
Member Nylander, I appreciate that. And I have advised my client, I'm their local Nevada counsel, but I have advised them that your staff is in communication with staff in other states. So they are aware of it. We would kindly request that the option, Member Durrett and yourself, as proposed by Chief Investigator Staley, be considered by the board moving forward today with some sort of stipulation. We understand it would be a conditional approval and we'd need to come back. And we agree, my client agrees to provide the information Chairman Douglas requested about the specific divestment of shares, but we would kindly request the board consider that option.
Chairman, may I make one more comment, and I'll try to hold any others on this? I know
No,
we need to move on.
that's fine. I appreciate this. It's like I said, some of it's new ground, so please go forward.
Thank you. I think this one's particularly important as well because Curaleaf is so visible, and we would like you to be a leader to other licensees. Mr. Clateman said he's not sure where the violation would be in that transfer if it was less than 5%. The NRS at the time was that any transfers whatsoever had to be approved. So the fact that taxation may not have had a clear path forward is a mitigating factor, but it doesn't mean there wasn't a violation. So, and it's a mitigating factor we've acknowledged in the past and likely will going forward. But I just want to reiterate, and we've said it a couple of times, but what Chairman Douglas and Member Nylander said, and these are some of the top attorneys in the entire state, a former Supreme Court justice, a former Gaming Control Board member, that you have to fit within the Nevada regulatory framework. So going forward when licensees and when you come before the board, I, as a member, I'm not going to speak for the other ones, want to hear much more about how you're complying with Nevada law than this is how it works with publicly traded companies. This is how it works with the Canadian Stock Exchange. By all means, include that as an information, but no matter what, you're going to have to comply with the Nevada regulatory structure. Thanks.
We have an item on the floor. At this point, we have no motion. Do we have a motion from someone that wish to parse?
Yeah, Mr. Chairman, I'll take a shot at it if that's okay with you. I would move for approval of item number 4A as stated on the agenda, conditioned that the transfers not be officially approved or take place if they're pending until the licensee and the Attorney General's office and our staff are able to reach a stipulated settlement agreement in respect of what appears to be at least some transfers that occurred without approval. And that would hopefully would appear on our May agenda so that then we can move forward, the company can move forward. And again, this is consistent with what we've done on previous, these legacy issues that we inherited from the prior regulatory regime. And so that would be my motion.
Chair Douglas, if I may, Chief Investigator Staley, would it be appropriate to include in that motion the approval of the waivers requested by the applicants, or would it be appropriate to handle that at the agenda in which the potential settlement is addressed?
From my standpoint, can't speak for Dennis. I would like to hold the waivers until the matter came back to us, if we're going to go forward with this motion. But that's just me, and it's Dennis's motion, so I'll let him state his position.
No, Mr. Chairman, I would go ahead and, because this is going to come back in the month, I don't think the waivers are necessary unless the company thinks otherwise, but the waivers would come up at the next meeting. We could actually include them as part of the stipulated settlement, I assume. Yeah, to handle it that way.
We have a motion on the floor. Do we have a second to this motion?
Member Durrett, I second.
We have a motion and a second. Any additional questions or concerns that anyone wishes to raise? Hearing none. All in favor of the motion as made this date, please say aye.
Aye.
Aye. Any opposed? Anyone wish to abstain? The motion has been carried. This matter will be, at this time, the remainder, hopefully back on next month for final resolution, as so stated. Thank the licensee and counsel for their assistance this morning. This is just not an easy issue at this time, but we're trying to make it easier despite the discussion today.
We appreciate it. Thank you.
Thank you.
Mr. Chairman, if I could make a comment.
Yes.
This is not necessarily related to the prior item, but as we go forward, we've been discussing these TOI numbers, but they're not on the agenda. So we have on the agenda, and this has nothing to do with Curaleaf. Just procedurally, probably for Mr. Staley and for Tyler. So we have these kind of file numbers, but we don't have the TOI numbers. So I just think for public notice purposes, we need to decide on one or the other. Like the TOI numbers appear in our reports, but they don't appear on the agenda. So for example, we've been talking about 19071, which we didn't have any issues with on the last item. But that doesn't appear on the agenda anywhere. So I just, for procedural purposes, I'm just so that we're all on the same page and that everyone knows what we're talking about, we might need to restructure that to just make it clearer. Maybe we go with the case number only, or we just go with the TOI number, whichever one, but it's, I just feel like we need to make it, and I don't know which one is best, but if we can just make that clear as we go forward for purposes of the agenda. It's just a quick comment, Mr. Chairman.
Thank you. No, it's important for consistency. and for those trying to follow along.
Thank you, Member Nylander. We'll make that change.
That moves us to item B, Euphoria Wellness LLC.
Thank you, Mr. Chairman. For the record, this is David Staley, Chief Investigator. Item B are TOI applications for Euphoria Wellness LLC or Euphoria. TOIs number 18009C, 19020, 21019, 21042, and 21046 request approval for internal reorganizations of ownership among various existing Euphoria shareholders. TOI number 18009B was a request for a sale of ownership to Live Free Wellness LLC, but the companies have requested a withdrawal of this application as the proposed transaction has been canceled. In addition, Euphoria has requested waivers pursuant to NCCR 5.112 and 5.125 of the requirements of NCCR 5.110 regarding a review of all owners. Euphoria has adequately addressed the items required in NCCRs 5.112 and 5.125 to allow the board to approve such waivers. Staff suggests that if approved, the boards limit Euphoria's 5.112 and 5.125 waivers to expire on such agenda date as Euphoria's next TOI application is heard. Staff identified no areas of concern with this application. I am available for any questions, and my understanding is that Nicole Lovelock and Clint Cates are present today via Zoom to address any questions you may have as well. With that, Chair Douglas, I'll return this item back to you.
Thank you. Any board members have any questions they would like to put forth for the record of Mr. Staley or the licensee before I ask the licensee to make any comment?
Good morning, Nicole Lovelock, counsel for Euphoria Wellness. I have with me Darlene Perney, the managing director of Euphoria Wellness. Thank you. We have no comments unless there are any questions from the board.
Thank you, and thank you for being here today. If we have no concerns based upon the report that had no areas of concern, can we have a motion for approval subject to the conditions that were set forth?
Mr. Chairman, this is Member Nylander. I would move for approval of item 4B, Euphoria Wellness LLC, and that approval would be conditioned that Euphoria's waivers pursuant to NCCR 5.112 and 5.125 are limited to expire on such agenda as Euphoria Wellness's next TOI application is heard.
Thank you. Do we have a second?
Member Durrett, I second.
It's been moved and seconded. Any additional discussion? Hearing none, all in favor, please say aye of approval with the condition.
Aye.
Aye. Any opposed? Any abstentions? Hearing none, matter carries. We note for the record that item C, Compassionate Team of Las Vegas, has been continued to the proposed May 25th meeting date. That moves us to item number D.
Thank you, Mr. Chairman. David Staley for the record. Item D are the TOI applications for Air Wellness, Inc., or AIR. TOIs number 19032, 19046, and 19046A were filed by AIR requesting approval to acquire Live Free Wellness LLC, Washoe Wellness LLC, and the Canopy NV LLC. In addition, AIR has requested waivers pursuant to NCCR 5.112 and 5.125 of the requirements of NCCR 5.110 regarding a review of all owners. AIR has adequately addressed the items required in NCCRs 5.112 and 5.125 to allow the board to approve such waivers. Staff suggests that if approved, the board limit AIR's 5.112 and 125 waivers to expire on such agenda date as AIR's next TOI application is heard. Staff identified no areas of concern with this application. I am available for any questions, and my understanding is that Alicia Ashcraft and Clint Cates are present today via Zoom to address any questions you may have as well. With that, Chair Douglas, I'll turn this item back to you.
Before we hear any comments, if necessary, from the licensee or council, board members have any additional questions or issues they wish to raise as to this proposed TOI?
So, Mr. Chairman, this is Member Nylander. Mr.
Yes, sir.
The reference in the reports to non-managing shareholders, are they actually members of these LLCs, or are they shareholders within other holding companies?
Mr. Staley, can you respond to that?
Yes, sir. Mr. Nylander, or Member Nylander, can you refer me to the page?
Page 3 of the report, where we have the org chart. There's an indication that several members are considered non-managing shareholders.
Apologies, Member Nylander, this is council. I'm unable to hear you. I'm unsure if others are also having an issue. But if you could speak more directly into the microphone, I think it would be helpful.
Yeah, so it's page 3 of the report, Mr. Staley. Can you hear me okay?
Yes, sir, I can.
So there's a reference to non-managing shareholders.
Member Nylander, Air Wellness Inc. is an incorporation, and I think that was just using the wrong terminology. So Air would have several, it has shareholders that are not considered managers. Since it's not an LLC, they wouldn't necessarily be members or managers since it's a corporation. I think we just included the wrong language in there.
Okay, I'm getting it. Hold on just a second. I think I'm getting it.
Excuse me, I cannot hear whoever's speaking.
Mr. Nylander is speaking.
Thank you.
So understood.
Thank you.
Any other questions, or was that satisfactory that there was a nomenclature issue?
No, I'm good, Mr. Chairman.
Thank you. The licensee wish to state anything since there were no particular areas of concern for council?
Amber, if you could unmute Mr. Ashcraft and Mr. Cates, and then once you're unmuted, if you'd like to address the board, you may. Ms. Ashcraft, are you available?
Sorry, yes. Can you hear me now?
Yes, we can.
Very good. Good morning, Chair Douglas, Director Klimas, and board members. For the record, Alicia Ashcraft of the law firm of Armstrong Teasdale on behalf of Air Wellness. We just want to take a moment to thank Chief Staley and Investigator Branner. This is, again, one of those that's been pending for a couple years, so we appreciate all their efforts to bring this to finality and bring the item before the board. Happy to answer any questions if there are any. Otherwise, we request approval of this agenda item. Thanks so much.
Thank you very much. With that, unless there are areas of questions, if we can have a motion for approval subject to condition.
Mr. Chairman, this is Member Nylander. I would move for approval of item D, item 4D, as stated on the agenda for Air Wellness, and that approval will be conditioned that the waivers pursuant to NCCR 5.112 and 5.125 are limited to expire on such agenda as Air Wellness' next TOI application is heard.
We have a motion on the floor. Do we have a second to that motion?
This is Jerry Merritt. I second.
We have a motion, we have a second. Any additional discussion or concerns? Hearing none, all in favor, please say aye.
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 Any opposed? Any abstentions? Hearing none, the motion carries. That moves us down to approvals and regulation, item 5.
Thank you, Chair. So agenda item 5 is an informational item presented as a notice to the board of establishments that have been issued their final license since the last board meeting. So with that, I'm going to ask Steve Gilbert, head of licensing, to please present on this notice for this month. Mr. Gilbert.
Thank you, Director Cannabis. Good morning, Chair, members of the board. Steve Gilbert for the record. Agenda item 5A is an informational item presented as a notice to the board of establishments that have been issued their final license since the last board meeting. We have one license to note today. Compassionate Team of Las Vegas, LLC, RC048, is an adult use cultivation location located at 2603 South Highland Drive in Las Vegas. They were issued a medical cultivation license on April 11th of 2019. An inspection of the facility was completed on December 3rd, 2020, and the facility was in compliance with the NCCR and Title 56 of NRS. A statement of no deficiency was issued on December 16th, 2020, and on February 25th, 2021, CCD staff conducted a follow-up inspection of the facility and issued the final adult use cultivation license. With that, Chair, members of the board, I'm happy to answer any questions.
Any members of the board have any questions as to this matter? It's on for information only. All right, thank you very much. We'll go to our agenda. Briefing by Mr. Klimas.
Great, thank you. Chair, members of the board, today I'll provide another update on the current legislative session, as well as a couple other updates for the board's information. Although it's only been a month or so since our last board meeting, these legislative months seem like years, as you all well know. No more so for some reason than for the Cannabis Compliance Board this year. But anyway, a couple highlights. The CCB closed its budget in front of the joint money committees on April 12th. The CCB's bill, Senate Bill 49, it's going to be scheduled to be heard in the Assembly Judiciary likely later next week. Other pieces of legislation, as you know, AB 341, which would authorize cannabis consumption lounges, is currently awaiting a hearing in front of the money committees, as is AB 322, which would authorize vendor licenses and permitted cannabis vendor events. SB 235, this would make changes to the dual licensee structure. This is kind of moving towards a single cannabis license for both adult use and medical, is awaiting its next hearing in front of Finance. And then another to note is SB 168, which we talked about earlier in agenda item 3. This would codify curbside pickup and provide for some regulatory flexibility on packaging and advertising restrictions. And it's also awaiting its next hearing. There's a number of other smaller cannabis bills that we're tracking as well. I do want to say this, understanding that we don't know for sure what passes and what doesn't. This board and CCB staff likely have a very busy year ahead of us beginning in June. I'd also like to say that it's going to be very important for the public, industry, and other stakeholders to be ready to get engaged on what I anticipate will be some serious policy discussions around implementation of various pieces of legislation. The Advisory Commission will likely meet for the first time in early July. This will allow for the board to digest legislation passed during the session and compile its requests of the commission to study and develop recommendations around any new cannabis programs or policies. If some of the bigger program changes do pass, it's going to take significant effort to develop these regulations around the programs and ensure the right pieces are in place so they work both for the CCB and for the industry. We are, of course, ready for these challenges, but I'd again ask that stakeholders begin to prepare for these upcoming discussions. So I'll have much more to come from this update as the session comes to a close. Lastly, I would like to point out to the board that last week was April 20th, also known as 420. This is considered an official cannabis holiday. Historically, this is a day that we see larger sales with many establishments taking advantage of the holiday to push deals. Some of them host events and other gatherings on site or in parking lots. Our CCB agents on Tuesday visited a majority of our cannabis retail facilities in Clark and Washoe County, as well as in Carson City, to perform compliance checks. And I'm happy to report that we found minimal issues of non-compliance and that our presence was generally well received, if not expected. So I would say I appreciate CCB staff work on this and ensuring our industry remained in compliance. And I certainly appreciate our industry for recognizing the importance, even on a cannabis holiday, that we have a duty to remain compliant and safe. So thank you for all involved in this year's possibly toned down 420. With that, Chair, that's what I have for my director's report this month. A couple smaller board agendas lately as we finish up a busy legislative session, but look forward to the work ahead.
The only question, and it's an open question because I don't expect you to have the answer at this point. Hopefully, without a crystal ball, are we looking at possibly June or July to having a public meeting? Opposed to a Zoom meeting?
It's a great question, and without that crystal ball, no, I would say that it sounds like we could potentially looking at June to host the first in-person. We have not had an in-person meeting as the CCB proper, so we are planning for June at this point.
I know that there's been pressure on the legislature where they've lifted some of their restrictions to allow the public back in, but other public buildings are still closed at this point. We are in a public building, so we are under that mandate, I understand. So I just raise it. We're concerned. We would like to allow the interchange with the public if at all possible, as we try to grapple with issues that are out there.
Well, we appreciate that, and certainly we will plan as much as we can, knowing that this last year has taught us a lot of lessons about planning. So we are looking towards June.
Item 7 is our next meeting is May 25th of 2021, unless there's some kind of change. That's our scheduling date. Items for future agendas, if anyone has any, if they would get them to our executive director or to myself, that would be appreciated. As indicated, some of those items that we've talked about in the past are kind of tied up a little bit with pending bills before the legislature, so I understand why we're kind of letting our powder stay dry at this point, so to speak, on those items. But if you have something that's pressing or something you'd like to get out for some discussion, if you get them to us, we can go forward. And the age-old question, item number 9, do we have any public comment? We had none at the beginning. Have we raised any public comment?
Chair, we do not have any public comment that we received during the meeting.
I hate to say I'm disappointed, but with that, if we can have a motion to adjourn.
Chairman, I would go ahead and move to adjourn the meeting.
It's been so moved. Do we have a second?
This is Member Young. I will second that.
Thank you. We are adjourned.
Thank you.